Hello. My name is Erin, and I'm a lawyer with Nobles Law. Welcome to today's webinars, Wills, Trust, and Incapacity, What Parents Need to Know. I'm really happy that you're here today and joining us. Nobles Law is an estate planning and administration law firm based on Boston's North Shore, serving clients virtually throughout the Commonwealth. At Nobles Law, our goal is to help our clients get peace of mind from knowing that when they die, the people that they love will be kept out of court and out of conflict. So, as we're all getting settled in today, I wanted to let you know that this webinar will last about 30 minutes. And I'd love for you to stay for the whole thing. If you need to leave early, I have put my contact information in the chat, and certainly feel free to reach out to me. If you can stay until the end, we'll be having a special offer just for being here with us today. I also wanted to let you know that I'm coming to you today from my home office. So if you hear rustling in the background, those are my two dogs, Gizmo and Bean, or as I call them, the law dogs. We're going to keep this kind of informal today. So if you'd like to put questions into the chat, certainly feel free. I'll try to address those, but if I don't have time, if you want to leave your email address, I'll get back with you. Or certainly reach out to me again at the information that I've provided. In the next 30 minutes, we're really going to be talking about the building blocks of estate planning, why this planning matters, and who really benefits from this kind of planning. At the end of the webinar, I really hope that you'll feel like you learned something, and also that you'll feel empowered to move forward, either creating your estate plan or perhaps taking a second look and revising a plan that you've already done. Just to make sure that the plan is one that will truly support the people you love and work when it's needed. So as we get started, I just want to share a little bit about me. I am a Suffolk University Law School graduate, although you can probably tell from my accent that I am not a Massachusetts native. I'm originally from Florida. I'm licensed in Florida and Massachusetts. I was a litigator or a trial lawyer for about the first 10 years that I practiced law, first with a big Boston law firm and then with state government. Eventually, I just got frustrated with litigation because I really saw that so many of the disputes that I was bringing to trial could have been avoided, or the consequences could have been significantly mitigated if there had been proper planning in place. So when I started my own firm, I decided to really focus on helping families create lasting legacies. And I'm not just talking about money. I'm really talking about preserving family harmony across the generations and protecting those unique bonds that really make family life special. So let's jump right in. And the most basic question, I think, is what is an estate plan? Well, simply put, an estate plan is a series of legally enforceable documents that you create in advance to nominate someone to make decisions for you if you become incapacitated, and to nominate someone to administer your estate after you die in the way that you want your estate or your property to be distributed. But while the documents are really important, estate planning is really more than that. It's the whole process of becoming educated and empowered to make wise decisions for the people that we leave behind, and also making sure that the process has been put into place to make sure that the decisions that you've made don't become outdated or stale. And we'll talk a little bit about that. But first, I want to address 3 common myths about estate planning. And the first one is that you only need to do estate planning if you have a lot of money, if you're very wealthy. Estate planning isn't for everyone. It's just for the rich. Well, I just can't tell you how wrong I personally feel like that is. As I said, estate planning is really about making those intentional decisions for your life and for your death. If you have minor children, it's about choosing someone to care for them and creating the financial underpinning so that the guardian would have the ability to do that. And I really can't overstate this, it's about making the whole process as easy as possible for those you leave behind. Good planning, and I've seen this, can be the difference between your loved ones having to make a few phone calls to resolve your estate and having to spend months or maybe even years making court appearances. The second myth about estate planning is I don't need to do it because I'm married and my spouse knows what I would want and they're going to get all my stuff anyway. Well, as a threshold issue, your spouse may not know what you want if you haven't had those conversations about end of life care and your thoughts and your values with respect to that. And when it comes to inheriting your asset, yes, typically your spouse is going to inherit most of your assets, but perhaps not everything, especially if it's a blended family situation. And it might not even make sense from a tax perspective to just pass all your assets directly to your spouse. And we're actually not going to talk very much about Massachusetts estate taxes. But if you potentially have an asset of an estate valued at $1 million or above, you really need to think about that, doing some tax planning. And the third myth about estate planning is it's very, very expensive to work with a lawyer. I just don't have the money. So I will say that estate planning is really not an area where you want to do bargain shopping. But not planning really shifts the burden of paying that cost onto your heirs. That's your partner, that's your children. Because not planning virtually guarantees that your heirs will have to pay much more. And it increases the likelihood that there's going to be disputes. So there may be multiple attorneys involved. Attorneys and other professionals who are all making money off of your estate, money that would otherwise go to your children and your heirs. And since it typically takes a long time, a lot of money to unwind an estate, the rate that your heirs will end up paying would be much, much more than what most estate planners are going to charge to just set up your estate properly in the first place. So this seminar is called Wills, Trusts, and Incapacity, but I'd actually like to flip the script and talk about incapacity first. So speaking of expenses, this is one area that can get very expensive very quickly. And because you can be incapacitated or unable to handle your affairs for a long time, it can go on for months or years. Anyone who has been following the saga of Britney Spears' conservatorship knows this very well. So let's start by talking about incapacity. Let's define it. So incapacity means that you are living, but you are unable to care for yourself, your property, or your children. Without a plan, an incapacitated person can really suffer from a loss of autonomy because they can't communicate important decisions. And by the time you become incapacitated, it's obviously too late to choose who the person you would want making those decisions is. And that's why it's really important when we're talking about incapacity to create an advance directive for healthcare and a financial power of attorney well in advance of when you may need it. Now, I just want to say that it's really important to not be confused. Incapacity should not be confused in any way with having physical health problems or being sick. You can have physical health problems, even a progressive disease, and still be fully capable or partially capable of making your own decisions. But as I said, in the event that you've been determined by a physician to be incapable of making those sorts of decisions, you really want to, in advance, have chosen someone to be your medical advocate and your financial advocate. So let's talk about medical care first, because that's sometimes something that people don't think about in estate planning. In Massachusetts, now, the law with respect to medical decisions is something that's going to be somewhat different in all 50 states. So what I'm talking about right now is the law in Massachusetts. So here in the Commonwealth, the document that allows you to choose a medical advocate is called your healthcare proxy. You'll choose one agent at a time, but you'll want to choose at least one, maybe two or more backups. And this is in a situation only where your doctor has determined that you can't make, or you could make, but you can't communicate your own medical decisions. So it's important to choose this agent very carefully and give it real thought. Your attorney can help you weigh the pros and cons of choosing some of the people that you might come to mind quickly: your spouse, your parent, maybe your adult child. And the reason is you want someone as your medical advocate who is level headed, who understands your wishes for long term care and end of life care and will respect them. And also, you want someone who is assertive and who is able to stand up for you and your rights in front of your medical team and perhaps in front of your family or other loved ones who may have different opinions. Alongside with creating that healthcare proxy, you can also create something called a living will. Now, a living will is completely different from your last will. And I really, truly wish they had different terms because it's very confusing. Think of it this way: your last will governs the distribution of your property after you die. But your living will is a document where you can spell out the types of interventions that you would or wouldn't want during your lifetime, medical interventions. Examples of this might be that you do or do not want to be resuscitated if your heart stops. You do or do not want to be intubated or ventilator dependent if you can't breathe on your own. Or you do or do not want to be fed through a feeding tube if you're unable to be fed through the mouth. So in Massachusetts, the decisions that your healthcare proxy makes would supersede anything that you've written in your living will. And that's why sometimes people say a living will isn't enforceable in Massachusetts. And because your proxy can override what you've written in that living will, it's another reason it's really important to pick the right proxy. But even though, it's not strictly speaking an enforceable document, I still think it's an excellent idea to create a living will anyway, because it can provide guidance to your proxy. And also evidence as to, not in a court of law, but evidence as to what you would or wouldn't want done. And that can help them make decisions in an emotionally fraught situation. The second document that could come into play during your incapacity is your durable power of attorney for finances. Now, this is analogous to the healthcare proxy, except that it allows someone to make financial decisions on your behalf as opposed to medical decisions. Now, this could be opening and closing a bank account, selling your car, applying for Social Security, or any of those things that you can do individually: getting a credit card, closing a credit card. The financial power of attorney gives someone the ability to execute those steps on your behalf. Now, one thing I always suggest is that when clients are putting together documents for themselves, they think about their parents and, if applicable, their soon-to-be adult children, not as their own agent, but making sure that they have their documentation in place. And also making sure that you, as the parent or the child, as the case may be, have access to those documents. This will allow you to avoid tremendous hassle and expense in an emergency, because if you have the documents, you can take action immediately and you don't have to worry about petitioning the court for authority. If you are a parent of children under 18, it's really important for you to execute a third document for incapacity, naming a guardian for your minor children. That's because the guardian that you pick in your will isn't an effective designation unless you have died. And there can be many situations where you're temporarily unable to care for your children, but you haven't passed away, and so the will has no effect. Naming a pre-need guardian in a freestanding appointment of an emergency guardian can protect your kids from ever being taken into state custody, because the police or the authorities have a plan instead of not knowing who is authorized to take your kids. So now that we've talked a little bit about incapacity, let's talk about what might happen at your death. And we're going to talk about the two documents that really control the disposition of your assets: your will and a trust. But first, I think it's really important to talk about what might happen at your death if you don't have any kind of estate plan. So one of the things that I always tell clients is that even if you don't have a plan, the Commonwealth of Massachusetts has one for you, and it is called probate. So probate is a court process that has to happen when someone dies owning property to figure out if they have any debts and to figure out what to do with that property. So if you die before your spouse, he or she may be able to avoid the worst of probate if you own most of your assets jointly, like your house or your bank accounts, or if you've named your spouse as a beneficiary of your accounts, like a brokerage account, life insurance, other qualified retirement accounts. However, if you have any individually owned assets, like a bank account or an investment property, it's likely that at your death, the property is going to need to go through the probate process. And it is a near certainty that without planning, at the death of the second spouse or the survivor of the two of you, almost all of the property will have to go through probate if you haven't planned otherwise. This means your parents, your kids would be dealing with a court process at the same time that they're processing grief from your death. So let's walk through probate so you understand exactly what it is. So let's assume that I have died without an estate plan. Very bad lawyering. So the first thing that's going to happen is that my bank accounts, my investment accounts are frozen. Nobody can access the accounts, not to pay my mortgage, not to pay for my funeral. Hopefully, someone will come forward and start to pay for these things in the hopes that they'll eventually be reimbursed from my estate. So in order to get that process of being reimbursed from my estate processed, the first thing that's going to happen is that someone is going to need to go forward and file a lawsuit in the probate and family court of the county where I died. A newspaper announcement that this lawsuit has been filed will be posted, and this alerts possible creditors that an estate has been opened, and that it might have money in it. So when I said someone has to come forward, I just want to clarify that that could actually be anyone. Oftentimes it's a surviving spouse or an adult child, but theoretically, it could even be one of your creditors who goes forward and opens the estate because they want to get paid. So as I said, there is a newspaper announcement. And so it is a public process. And I say this, and I think parents really need to understand this. The probate process itself is public, which means anyone can go down to, not only do you see the published announcement in the newspaper, but additionally, anyone can go down to the courthouse and look up the estate. So anyway, I have died. And now my personal representative, the person who has filed the lawsuit, has to go out and see if they can find all of my heirs. If all of my heirs can be found, and if all of my creditors who come forward can be paid, the probate process might be over in about a year to 18 months. And by over, I mean that that's finally the point where distributions from whatever's left over can be made. As we all know, some contested probates, however, go on for much longer. There are multiple properties in Melrose, one of the hottest zip codes in the country, where the houses can't be sold because they're caught up in the probate process. Families can't move forward, and they are perhaps at risk of a downturn in the market, negatively affecting what they could have gotten for their house if they could have sold it. And I think the worst part too of the whole probate process and the whole process of not having planned is that how can your personal representative necessarily identify all of your property in the first place? I always talk to my clients about the importance of organizing your assets so that your heirs are not going on what I call an Easter egg hunt. Going through your email, going through your personal belongings, your computer, to try and figure out where you had bank accounts and what the balances of those bank accounts might be. Unfortunately, because oftentimes without planning, estates aren't organized, that property could eventually end up lost and going to the state. And I like to share this figure that kind of blows my mind. In the Massachusetts Department of Unclaimed Property, there is $3 billion just sitting there. That's a billion with a B of property that has been lost or misplaced. It is now, could have been helping out the heirs left behind and is now doing nothing but just sitting in a state account. And anyway, when it's all said and done, whatever assets have been determined, established, and not liquidated by creditors, they're going to go to my heirs outright. And so if I have heirs under 18, my kids, my nieces and nephews maybe, the court is actually going to need to appoint someone to manage this money for them until they come of age, at which time they get the balance of the accounts outright, no protections, in a lump sum. And so that's probate in a nutshell. It can cost 3 to 5% of the gross value of the estate. It's pretty expensive. So let's assume that my estate is worth $700,000. That's my condo, that's my bank accounts, those are my investments. The probate could potentially on an estate like this be upwards of $35,000. Fortunately, there are many strategies that you can put into place to reduce these fees or perhaps even avoid probate entirely. So the mechanisms that we attempt to use to reduce these fees or perhaps eliminate them entirely is going to be a will, a last will and testament, or a revocable living trust. These are two techniques used to pass along assets to your heirs, and they have pros and cons. So a will is a document that comes into effect when you pass away, and it states exactly how you want your property to be distributed. People sometimes don't realize, however, that creating a will does not allow you to skip the probate process. You have to go through the process of probating the will. Having a will that specifies what you want done does simplify things because you've already spelled out how you want your property administrated and you've appointed the person that you want to be in charge. But it's also, so it's not going to help you avoid that public nature. There's still going to need to be a publication, and it doesn't shorten the time period that creditors can come forward and make claims against your estate. And perhaps worst of all, especially for parents of kids under 18, it doesn't keep any of your family information private. So that's the importance of having a revocable living trust. A living trust is a separate document that you have in addition to your will that really gives you total control over how the assets will be distributed and allows you to circumvent the court process completely, except for having a judge sign off on the child guardianship determination that you've made. I called it a document, but it's really more than that. It's essentially a lockbox that you've given instructions to a trustee about how to make distributions. Most trusts that are created are fully revocable and amendable. And you can create trust instructions governing distributions, like prioritizing education, for example. And you can even create generational wealth building strategies with the trust that protect the beneficiary, the ultimate beneficiary, the person who benefits from the money, against their own creditors, against future ex-wives and ex-husbands, against other bad financial decisions that they potentially made. But creating the living trust document is not enough because unlike a will, you actually have to take concrete steps to fund the trust, to put money into the trust. So some examples of funding a trust might include opening a bank account in the name of the trust, or by naming the trust as the beneficiary of your cash accounts, your life insurance, and your real estate. So this can seem like a lot, and this really is why it can be really important to work with a specialist. Because as I said, it's not just about drafting the documents, and it's not even just about funding the trust. It's really about making sure that your loved ones know where your assets are, where the documents are, how they work, and who to contact. And it's about making sure that if you have children, the authorities have an alternative to taking them into state custody until they figure out who can take them. And it's about ensuring that your family knows how to find your assets and get access to them. Bottom line, it's about making sure that your loved ones have a complete plan and not just a confusing stack of documents. So at Nobles Law, I'm really proud of the process that we've created to make sure that that never happens. And it was really born out of my experience in litigation. Our goals are always to clarify exactly what you need and then work with you rather than tell you what you need. Work with you to make sure you understand the plan that you've created. And then to help you maintain it effectively, affordably throughout your life, because you are going to need to make changes. And we really want to guide the people that you love um, and ensure that the right people are making decisions about your assets and about your kids. And also, if there are people who shouldn't be making decisions about your assets or your children, that they're never empowered to do that. And that's what I mean about keeping people out of court and out of conflict. So the process we used to get started is called the Family Wealth Planning Session. Oh, there's one of the law dogs. I don't know. Which allows us to get to know you and your family so we can really prioritize your goals. So I've really seen and heard firsthand from people that this helps them get more financially organized than they feel like they've ever been before, to really make those informed, empowered decisions. I really do mean this. Our clients actually choose the right planning level and the fee that they're going to pay for their plan. The typical range is going to be between $2,000 and $6,000, depending on the level of complexity. And everything we do is a flat fee. So read to in advance, there's no surprises. That's Gizmo. So I told you that if you hung on until the end, I'd give you our special offer, and here it is. The Family Wealth Planning session usually is $750 because it's a working session. Where we actually review your assets and put together a plan for you. But to say thank you for being here today, I'd like to offer the Family Wealth Planning session free, completely free, no obligation, plus $250 off of your plan when you book online today or within the next 24 hours. Just reach out to me through email. It's the email that's in the chat, and I'll give it to you again. It's erin@nobleslaw.org to let me know that you listened and you watched this webinar. And I'll send you the scheduling link, and you'll qualify for the special offer. Just use the phrase golden ticket so I'll know that you actually watched until this point. So remember, estate planning is about much more than a set of documents. So when it's time to write or revise your will, your trust, your healthcare advance directive, or your financial power of attorney, or any other document that you may think you need, reach out to a professional who'll take the time to get to know you, to get to know your family. Please call or email me at Nobles Law if you have any questions. And I'm really just so grateful you spent time with us today. Thanks so much.